Welcome once again to the Law Professor YouTube channel. In this presentation, we shall be looking at the law of maintenance under the Matrimonial Causes Act of Nigeria. We have laid emphasis now in this presentation on the Matrimonial Causes Act. To that extent, I'll be sharing my screen as usual. The issue of maintenance, like I said in the first presentations, straddles the various components of the Nigerian legal system. We know when you talk about family law, you talk essentially about a plural legal system. I'll continue to emphasize that. And when you talk about a plural legal system, you're talking about the English-based system that we call the statutory system. You're talking about the customary system, and you're talking about the statutory, the Islamic system. But for this purpose, we are looking at the Matrimonial Causes Act as it relates to maintenance, which is usually called ancillary reliefs. And what are the learning outcomes for this presentation? What are our learning outcomes? In this video, we would learn, we understand what maintenance means under Part 4 of the Matrimonial Causes Act of Nigeria. We would also understand who is capable of applying for post-divorce maintenance under the Matrimonial Causes Act, and who can apply and for whose benefit they can apply. And we would understand the kind of marriage that the MCA governs. We will understand the concept of children of marriage, and then the meaning of relevant time as it is used under the Matrimonial Causes Act. At the end of the day, you should be able to apply these principles for the exercise of the court's discretion in any discussion on the law of maintenance. Now, the legal framework, the applicable laws in this regard, as I've said, the maintenance is what we call ancillary relief, a relief that typically is tied to the mere relief of divorce or nullity or any other matrimonial cause. We are not going to go into the discussions as to whether it can be granted independent of a principal relief in this video. We will take that in subsequent presentations. And so you find the law of maintenance under the MCA under Part 4 of the Matrimonial Causes Act. And the relevant sections of the law are Section 69, 70, 73, 74 to 75. And of course, being an ancillary relief, some of these sections are also general sections. They apply, of course, to other ancillary reliefs like custody of children and settlement that will be taken subsequently. You also look at Part 5 of the MCA, which relates to recognition of decrees under Sections 80. And Part 8 of the MCA, which deals with enforcement of decrees, Sections 88 to 94. Then you look at the matrimonial causes rules, Schedule 3. There are other laws that are also, if I can use the word ancillary to this, that will be mentioned in the course of the presentation, especially those that relate to the enforcement of these decrees, because there's no point in getting a decree of maintenance if you are unable to enforce it. And some of these laws are here listed. Now, when we say maintenance, we are talking about the financial order that the court makes on the application of a spouse to a marriage, a party to a marriage, for the benefit of that party, or for the benefit of children of the marriage. And maintenance in this context of the MCA can be given for the benefit of the husband, an ex-husband or ex-wife. We have explained the fact that we are talking about post-divorce maintenance in the context of the fact that the marriage is already distressed. Either it is divorce pending the suit or given at the end of the suit. That's what we are talking about. We are not talking about maintenance that takes place during the marriage as a component of consortium, which we have discussed in other areas of the law. So it is in this context, any of the husband or wife, look at Section 70 of the MCA, either party to the marriage can apply. So it will be is a gender-neutral provision. Is different from alimony that we know before, which is usually given in favor of a wife, in the light of the construction of what a marriage represents. You can see the case of Odibu and Olibu in that respect. You can have spousal maintenance or child maintenance. You can, so the court an order under Section 70 that you maintain an ex-spouse or the children of the marriage. So it can be given for the benefit of the husband or the wife. And it must be a husband or wife who applies for that maintenance. It is so important that Section 57 of the MCA says that the decree nisi cannot be made absolute, especially when it comes to children of that marriage, until proper arrangements are made for children of the marriage that are under 16 years, for their welfare, for their advancement, for their education. And these are things that the law of maintenance would take care of. Like I said, maintenance is financial order. There are other provisions of the MCA that deal with property awards, but we are looking at the law of maintenance in this context. Who are the applicants and type of marriage? And who are the beneficiaries? It's only the husband or wife of a statutory marriage that can apply. If I look at Section 69 of the MCA for definition of the spouse and the marriage and the children of the marriage, it talks about the fact that it must be a statutory marriage, including the one that is purported statutory marriage that is now rendered void. Okay, and then it can only be applicable to a statutory marriage. It excludes expressly customary and Islamic marriage. So if the couple are married under customary law, Islamic law, you cannot apply the provisions of the Matrimonial Causes Act. You have to look at the relevant customary law or Islamic law in that respect. Unless it's maintenance of children, then you can apply to the Child's Rights Act or Child's Rights Law of the state. Who can apply? It's only a party to the marriage. So a third party, maybe your mother-in-law, your brother, no, they cannot come and apply under the MCA. It is usually the party to the marriage, either the husband or the wife. You can apply for themselves or as a spouse or the children of the marriage. So a wife, for instance, can apply for maintenance for herself, or she could apply for the benefit of children of the marriage. Note what we said, children of the marriage, not just children. They must be children that in the technical sense of the word are regarded as children of the marriage. And the Section 69 of the Matrimonial Causes Act that I talked about gives us the framework for defining children of the marriage. In the light of the contents of that section, children of the marriage would include biological children of the couple together. They've been married for 10 years and they've had 3 children between themselves. Those will be children of the marriage. It could be an adopted child of the husband and wife as a couple, because under the law of adoption, the husband and wife as a couple could apply for adoption of a child. So if they had applied for a child while they were married, that child is a child of the marriage. Or if either of them, either as a man or as a woman, independently applied for adoption of a child during their marriage, but with the consent of the other, because the consent will be necessary even for the law of adoption. In that context, that child that is adopted either by the couple together or as individuals regarded as a child of the marriage. Then a child born out of wedlock between the husband and wife. Peradventure, they've had a child out of wedlock before they were married, and that child is the child of between the husband and the wife. That child will constitute the child of the marriage. Then any child of either party that is born out of wedlock, maybe the husband, for instance, while they were married, had a child with the first party, and that child has been accepted into the home as a child of marriage. Then, if at the relevant time of the divorce, the child is ordinarily a member of the household of the husband and wife, that child will be a child of the marriage. Then the child, of course, under the Matrimonial Causes Act, law requires that that child will be under 21 years of age, under Section 74, unless there are circumstances that make it imperative for the court to order maintenance for a child over 21 years of age. So these are regarded as children of the marriage, and unless the child comes in that definition, so it will not be qualified to be given maintenance. And so for the definition of children of the marriage, you need to see that Section 69. And so 69 also talks about that the child will be immediately, if that child was immediately, at relevant time, a member of the household, if the child that is born out of wedlock, for instance, and has been accepted, if at the relevant time, it's ordinarily a member of the household of the husband and wife, So in defining relevant time, Section 69 also gives indications that the time immediately preceding cessation of cohabitation, if they stop living together on the 29th of April 2024, then just before that was that child a member of the household. And if they had ceased, they had stopped living together as husband and wife more than one occasion, the last time that they ceased to live together as husband and wife, was that child that a member of their household? Or if at the time of applying for divorce, they are still living together as husband and wife, then the time immediately preceding the institution of proceedings. What we can take away from these provisions is that when you want to define child of the marriage, when you want to define marriage, you want to define relevant time, you need to look at Section 69 of the Matrimonial Causes Act for that definition. The essence of this presentation is therefore to make us understand what the maintenance represents under the Matrimonial Causes Act. That maintenance relates to financial order, like we said. It applies to statutory marriages. It is gender neutral, so you can give so many definitions. It is a discretionary remedy. It is not something that you come to the court and claim as of right. This, if you look at Section 70, which governs the law of maintenance in terms of how to award it. Look at Section 70, subsection 1, subsection 2. It talks about the one that you give pending suit and the one that is final in a narrow sense of the word final. You would see that the court must have regard, is the discretion of the court. Either party can apply for it. The court has its discretion if it looks at some factors that that section has listed as being made to give the maintenance. So it's not a property award, it's a financial award, it's a gender neutral award, either husband or wife can apply for it. Yeah, so you can give there are different ways, therefore, that you can look at maintenance under Part 4 of the MCA. The award is for the benefit of the spouse of that marriage, which is a statutory marriage, or children of the marriage. It does not apply to customary marriage, it does not apply to Islamic marriage. And then at the end of this video, I'm sure you also know how the law determines who is a child of the marriage. And we must be also be able to apply these concepts of relevant time. If a child is a child of the marriage, as defined by the relevant time, that child is a member of the household. So these are the basic components of the law of maintenance under the Matrimonial Causes Act of Nigeria. In the next video, we shall be looking at another aspect of the law of maintenance under the Matrimonial Causes Act in terms of types of award and how the courts are the factors that they will use to determine whether it's a party who has applied is entitled to maintenance. This is the Law Professor channel. Don't forget to like the video, share, and I'll see you at the next presentation.